Y'all hear me okay?
Yes,
Yes,
sir.
sir.
All right, Chambers County Commissioners, probate court come to order, some kind of court. Um, and if you're going to testify today, if you'll raise your right hand, please.
Potentially.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
All right, first on the docket, cause number 102 is said Robert Wayne Langston. Who is here on that cause?
Miss Lane, I see her
Do you see her?
at the bottom. There she
Oh, there
is.
she is.
I'm sorry. I'm sorry.
That's okay. Did we swear? You got somebody going to testify?
Yes, sir. I have Miss Desiree Langston.
All right, we need to swear her in. Raise your right hand, please.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
Yes.
Thank you.
You can put your hand down, Counselor. You may proceed.
Your Honor, I don't know if you recall Miss Langston. This has been a long, drawn out case, about 2 years, on a very small estate, but had debt. I have before the court today a motion to withdraw funds for attorney fees, commission, etc., and reimbursement. And we had just a little history of the case. There was a mobile home that had there's two sisters, my client and her sister, and the mobile home had a secured debt. The note was not paid. The estate was insolvent. There were trespassers that the sister would allow live in and out. It took us 3 or 4 times to try to get different sets of people out. Finally, we sold the land. The mobile home people repossessed the mobile home. There was a check placed in the registry of the court through court order and in a past hearing to sell to of the couple or the Marinos for 20,000 cash. That 20,000 cash is in the registry of the court, and we're here today on a motion to withdraw funds for out-of-pocket expenses, etc., of my client. So at this time, Desiree, can you state your full name for the court?
Desiree Diane Langston.
And Ms. Langston, have you filed a motion to the court to withdraw funds of the $20,000 placed in the registry of the court in the estate of Robert Wayne Langston?
Yes, ma'am.
And these are class 2, 3 claims that you have before the court, right?
Yes, ma'am.
Of those claims, are you, number one, asking for reimbursement of attorney fees that you paid approximately of $4,000? A filing fee of $530, an attorney ad litem fee of $500 for Ms. Clapper, and for a total of $530. Is that right?
Yes, ma'am.
Now, there may be ancillary fees we can't remember, but this is where we are right now.
Yes, ma'am.
And then your second reimbursement is we did a bond through Trey White State Farm Insurance with a premium bond fee of $260. Is that true?
Yes, ma'am.
Now, you've also been on this case for 2 years. Is that right?
Yes, ma'am.
And in this, you've had to use unusual efforts to collect and safekeep the estates. Is that right?
Yes, ma'am.
And in that was having to deal with vagrants on the property,
Yes, ma'am.
multiple letters by green card to leave. Did we have had constables show up or others to ask them to leave? Is that right?
Yes, ma'am.
Hearings, several hearings
Several.
with this. And finally, they're all gone and the mobile home has been repossessed.
Yes, ma'am.
Now, in that effort, you also have had to manage a secured debt of a truck, a 2018 Chevrolet truck. Is that right?
Yes, ma'am.
Now, that debt included that you started taking up the notes of $412 since September of 2023.
Yes, ma'am.
This old case for almost 27 months and more of $11,124. Is that right?
Yes, ma'am.
In that, you also paid insurance of $162 per month for 27 months for $4,374.
Yes, ma'am.
And then for a total so far, $15,498. Is that right?
Yes, ma'am.
Now, the original inventory approved by the court several years ago, at that time, the truck had a debt, but it was valued Blue Book around 15,000. Is that right?
Yes, ma'am.
In that, there is a remaining balance. I think it's dropped since, but it was $7,743.74,
Yes,
right?
ma'am. I'm almost at right at 7,000.
Okay, so you made this payment and you're asking this court that and requesting the court to grant you the authority after all the payments of the $7,743.40 are paid and insurance is maintained, that you be able to issue the title of the truck into your name alone.
Yes, ma'am.
Because if you were, it's upside down and there would be nothing to divide between you and your sister. Is that right?
Yes, ma'am.
And if you not paid the note and did all this, it would have been repossessed.
Yes, ma'am.
Then you're also asking of the remaining amount of issuing a check to your sister in the amount of $5,776. Is that right?
Yes, ma'am.
And a check to you for $5,776.
Yes, ma'am.
And there were some fees that I paid out of pocket to help along because it's really been a small estate with a lot of hard work.
Yep.
Of $1,158. Is that right?
Yes, ma'am.
I have no further questions for the court unless the court would like to ask a few questions, Your Honor.
Court has no questions. Is there anyone else on for this?
No, sir. The sister, I think, is incarcerated now. We tried to reach her. I think, have you talked to your sister?
I talked to Chambers County Sheriff's Department. She is in jail and she don't have a court hearing until the night, but she may end up back in prison.
Well, at least the fees may help her with bond or something, Your Honor. I don't know. And that would be a question for the court. Would you want us to keep the funds in the registry of the court if she, or Desiree, would you?
He's gonna have, so are you making an application on her behalf?
We made it, we did it on her behalf, but I don't have her to hand it to. Well, I guess, I don't know if I don't do criminal law. I don't know if I can hand her a check at the jail or not, but I don't think she could deposit it.
Well, is there any reason it can't stay in the registry of court until she personally comes to get it?
That's true. So we could leave that in the registry of the court and let her know that it's there for her. If I need to do a motion and order later to get it to her, I will.
I mean, as far as I know, this will suffice to get it to her, but I think she's gonna have to pick it up herself.
Yes, sir, I agree.
Okay, Christy, you understand that? Okay. All right, I'm gonna approve the order on the motion to withdraw for attorney fees, commission provided in Texas State Code 252.02 and 003.
And also the issuing of the license if she completes all debt, because she ended up paying really more than almost double in the end for the vehicle. If my client could have the authority to sign the title to herself.
Well, that's in your, is that in your order?
Yes, sir.
So
I don't know. I hope I did.
I mean, I approved the
Yeah.
order, so if that's in your order, then it's approved. I know you testified to that.
You know, that's a good point. I don't think, Your Honor, I put that in the order. I think, Your Honor, I forgot to put that in the order. I was adding the sums and proofing it and didn't add that part that I had authority to transfer. Can I send you a new order?
You can send a new order or you can send a separate order. I'm gonna
Okay,
approve it verbally.
I'll send a separate order. That would be better anyways.
Okay. Anything else?
No, sir, that's it.
All right, you ladies have a good day.
Thank you.
Thank
Glad you
you.
finally got this wrapped up. I know it's been.
Yes, yes.
All
All right,
right, take
thank
care.
you.
All
All
right.
right.
All
Bye-bye.
right, cause number 6, the state of Sophia Nadine Hall. Mr. Baker, good morning.
Good morning. Can you hear us?
We can. You may proceed, Counselor.
Well, I'm just just observing on this. Mr. Attorney, Mr. Lawrence Ulett filed a motion to withdraw.
Mr. Ulett?
Sorry, Your Honor. Yes, Your Honor. It's my motion. I'm not
Oh,
sure
there you are. Okay.
if the client is on. Sorry. But she was served with notice, and we filed a proof of service with the court, Your Honor. Not sure if the court wants to see if she's here or not.
You looking for your client?
Yes, I'm not sure if she's on.
Mhm.
Miss Wilkins?
Miss Wilkins is my client, Your Honor. She's the independent executive.
Okay.
State.
Who's your client?
Mary Rice, Your Honor.
I'm here, Your Honor.
Where are you? Wave your hand.
Samsung.
Okay, Samsung. Got you. All right, Counselor.
Yes, Your Honor. So essentially, Your Honor, so I have two grounds for my motion. The client and we disagree as to how to approach this case, and the attorney-client relationship has broken down to the point where we can't work together, Your Honor. Try not to go into any facts. If she wants to go into it, that's fine. But out of the attorney-client privilege, those are the just two main grounds there. The first ground, again, we don't agree as to how to approach the case. And the other grounds is our relationship has broken down to the point that we cannot work together.
All right, Miss Rice, anything you'd like to tell the court?
How to approach the case. I told them from my first phone call to that attorney's office exactly what my intentions were. That has never changed. He accepted the case knowing what I was hiring him for. And when he tried to change my mind multiple times, and instead of representing me, he demanded that I give my aunt $40,000 that she was asking for, even though there's no justification for it. And when I refused to just give her $40,000 without getting any justification, I believe he said the accounting, he made the threat that he can't work like that. That's not the kind of case he does. So I asked for a refund of any fees that he did not work, he didn't do, and then send me the paperwork to sign. And I never received any paperwork to sign, nor have I received any refunds of the money that I was charged.
Okay. You agree to you agree with him to withdraw his counsel?
Yes. I mean, he won't do what I hired him to do.
Okay.
He never sent the paperwork to do it, nor a refund.
The judge, for the record, may I respond to some of that?
You may.
I'm an employee of the law office of Brian Fagan, Your Honor. I don't make policy. She said that I accepted the case. I was assigned the case. So whoever she spoke to, and she did lay out what her agenda was. When she and I had the initial client meeting, I shared with her, as far as I'm concerned, there are facts, it could be 100% true, but we need evidence. It's a court of law. And what she proposed and what I could prove in court, I didn't think it was there. I proposed that we start at least with an accounting because one was due. And so she disagreed with that approach, but that's the only way I can get started with the case. I told her that day one. I can't proceed with something that she perceived will happen in the future. As far as that is concerned, Your Honor, I also mentioned to her that whatever the relationship with her and her aunt, she mentioned to me in the meeting that she admitted that she told her mom to include her aunt as the executor, which the will nominated her aunt as the executor, and the court appointed her aunt. as the executor. I've made it clear to her, you cannot just remove someone because you want them removed. That's number one. You have to have evidence of that. The other issue is as far as her and the accountant is concerned, there's a process for that. After I spoke to Mr. Baker, opposing counsel in this case, I told her as far as she wanted to keep the house, I said, that's before talking to Attorney Baker. I said, if you want to keep the house and there's no cash, you just have to maybe come up with the funds and take care of that. That way you don't lose the house if that's what you want. I told her that day one. And when I spoke to Mr. Baker, he confirmed it's an estate that it's property rich but cash poor. And I don't think I was wrong for giving her that advice, but she took offense to that. Yet again, I cannot help that, Your Honor, the state of the estate. It is what it is. And so that being said, I just want to address it. I'm not ignoring her. We just don't agree with how she wants it to be approached. The facts are the facts, and facts and evidence, two different things. I don't think the client understands that. Oh, Your Honor, one more thing. I believe as far as the relationship is concerned, she's written a negative review at the law firm and stated my name and defamed my character based on these facts. Suspect she may be filing a grievance, so I definitely want it in the record so that I can defend myself and my position. I am an employee of the law firm. I don't get to make policy here, and I certainly don't get to talk to her about her fees. That's it for the record.
All right. With that, I'm going to grant the motion to withdraw as counsel. Okay, Mr. Baker, anything from your side?
Nope. No, sir.
All right, thank you. You're dismissed.
Thanks, Your Honor.
All right, cause number 33, the state of James Patrick Nettles.
Mark Henry on behalf of the claimant 5 Point Credit Union, Your Honor.
Good morning.
Good morning.
Who else is on?
I have Patricia Hanley here as a witness to prove up our claim. We had filed an authenticated claim in this case, and it is an independent administration. There's a duly appointed executor, and the executor has neither accepted nor rejected our claim at this point that was filed on January 12th, 2026. I am prepared to go forward with proving up that claim today, but I'm not sure that I'm not sure that if that's the usual procedure to the court in a situation like this or not.
Well, we don't have this very often, so. But if you want to prove it up, we can go ahead and do that.
That would be fine. Well, I would call Patricia Hanley to testify.
And you may proceed.
Would you please state your name for the record?
Patricia Hanley.
Ms. Hanley, how are you employed?
I'm the Member Solutions Manager here at 5 Point Credit Union.
And in that position, are you familiar with the accounts of James Patrick Nettles, the decedent in this case?
Yes, I am.
All right. I'm going to try to share some documents. I'm going to try to share some documents with you. Get to the top here. Is my share screen working?
I don't see anything.
Don't either.
You may have to authorize me to share.
Okay. That'd be my court coordinator, Marangeli. Marangeli, are you on? There she is.
Can we see
All
now?
right, we can see it now, Counselor.
All right, I think it might have been me and not you. uh, Ms. Hanley, can you identify this first document here that we've marked as 5 Point Credit Union Exhibit 1?
Yes, it's a credit card application made by James Nettles and Shirley Nettles.
And that was executed by him on or about January 21st, 2016. 2016.
2016, yes, that's
Right.
correct.
All right. And I'm going to show you what we've marked as 5 Point Credit Union exhibit number 2. Can you identify this document?
Yes, it is a payoff for the credit card at that specific time on, which is February 3rd of 2026.
And what's the total payoff as of that date?
As of the 3rd, it is $20,860.27.
All right. I'm going to scroll down here and show you what we've marked as 5 Point Credit Union exhibit number 3 and ask if you can identify this document. It is multiple pages here.
Yes, it's a security agreement that was ordered for collateral purchase with the credit union.
All right. And what was the collateral on that originally?
It was a 2016 Keystone, Montana RV.
All right. And the original amount financed on that particular loan was $73,765.61, correct?
Yes, that's correct.
All right. I'm going to show you what's been marked as 5 Point Credit Union Exhibit 4 and ask if you can identify that document.
Yes, it's a current payoff as of February 3rd, 2026 for the travel trailer.
Now, the travel trailer was repossessed, correct?
Yes, that's correct.
And it was sold and the net sales proceeds were credited to this loan, correct?
Yes, that is correct.
All right. In your position with 5 Point Credit Union, are you the custodian of the documents that we've marked as exhibits 1 through 4?
Yes.
And these are true and correct copies of the 4 documents that we have presented to the court?
Yes, that is correct.
And it is these documents, they were made at or near the time of the events or conditions described in the documents. Is that correct?
Yes.
Were they made by a person with personal knowledge of the events or conditions, or made with information transmitted by a person with personal knowledge of the events or conditions reflected in the documents?
Yes.
Is it a routine course of 5 Point Credit Union and its routine habit or practice to make and keep these records?
Yes.
The records appear to be accurate.
Yes.
Is there any evidence that the records have been altered or tampered with?
No.
Your Honor, I'd ask that the court enter 5 Point Credit Union's exhibits 1 through 4 into evidence.
Go down.
All right. You actually signed off on the authenticated claim that was filed in this case. Is that correct?
Yes.
And as of the time that the claim was filed under the exhibit 1, the credit card contract, as of August, your testimony was as of August 11th, 2025, there was $19,698.19 due and owing under that contract, plus 15% interest, correct?
Yeah.
And that testimony, the documents that we brought before the court today is consistent with that testimony. We've just brought the interest forward with current loan information, correct?
Yeah.
All right. And then on, as far as the document that was marked as Exhibit 3, the promissory note disclosure and security agreement, you testified in the authenticated claim that as of August 11th, 2025, there was $40,893.84 owed, plus 8% interest on that particular loan, correct?
Yes.
And again, that testimony is consistent with the testimony you gave today and the documents that we presented to the court. It's just the 8% interest has been brought forward to February 3rd, 2026.
Yeah.
All right. And your employer, 5 Point Credit Union, has retained the law offices of Offerman and King to assist it in collecting the debt owed by Mr. Nettles, correct?
Yes.
And your 5 Points requesting that its attorney's fees and the amount we had in the claim was $3,000 be accepted as part of this claim, correct?
Yes.
Now, 5 Point Credit Union is the owner and holder and the person and the party entitled to collect these claims, correct?
Yes.
And have you made diligent inquiry into and examined the facts related to the claim that was filed in this case?
Yes.
Have all just and legal offsets and payments and credits known to you been allowed? And is all your testimony here today and the facts stated in the authenticated claim filed in this case true and correct?
Yes, they are.
Your Honor, I have no further questions of this witness. I'd like to give brief testimony to support the attorney's fees.
You may.
Your Honor, my name is Mark Henry. I am an attorney. I'm for 5 Point Credit Union, the claimant in the estate of James Patrick Nettles. I've been employed with the law firm at Offerman King here at 6420 Wellington Place, Beaumont, Texas 7706 since January 1st, 2016. I'm licensed to practice in the Supreme Court of Texas and all other state courts in Texas. I'm also licensed to practice in the Western, Southern, Northern, and Eastern District federal courts and the Fifth Circuit federal court. I'm familiar with the fees charged by attorneys practicing in Chambers County and surrounding counties, as I've been practicing in the Southeast Texas area since 1987. I am familiar with this estate and the time involved in presenting a claim to the estate, and I'm competent to testify as an expert to the reasonable and necessary attorney's fees in this estate. The law firm of Offerman and King charges $295 per hour for my time, as well as James King's time, who has also spent considerable time working on this case. These fees are reasonable in Chambers County area for attorneys with our skill and experience. We have to date expended approximately 5.2 hours of time at $295 an hour, which would be $1,534 in pursuing this claim on behalf of our client. It's anticipated that we'll incur about another 3 hours of time in pursuing the collection of this claim. We've also incurred to date $583.07 in expenses, which included filing a suit in Jefferson County Court at Law, which now we're in probate court, but that was filed before we knew of Mr. Nettles having an estate opened. And by the time this case is concluded, believe that $3,000 will be a reasonable fee, and ask that that be included as part of the claim. And that concludes my testimony, Your Honor.
Okay, have you filed an order or anything with the court to approve the claim?
Yes, Your Honor, there is an order on file. I did not file it. Mr. King did. If I could look at it just a second and see if it is yes, it was filed with the court, and I believe it will be sufficient. It establishes the claim as of August 11th, 2025, and adds generally the contractual interest rate and the $3,000 in attorney's fees.
All right, I'm approve the order as presented and approve the claim against the state counselor.
Thank you, Your Honor.
Thank you. Have a good day.
You too.
All right, cause number 132, State of Raymond Navarro Perino Jr. Mr. Davidson, good morning.
Good morning, Your Honor.
You may proceed.
Thank you, Your Honor. Vaughn Davidson appearing for the applicant herein. Raymond N. Perino, also known as Raymond Navarro Perino Jr., died on November 28th, 2025 in Baytown, Harris County, Texas, at the age of 81. 4 years have not elapsed since the date of his death. This court has jurisdiction and venue in that he had a fixed place of residence in Chambers County at the time of his death. To the best of my knowledge, the document that's been filed with the court, which purports to be his last will and testament dated September 3rd, 2015, was never revoked. And I would request that the court take judicial notice that the original is in the court's possession.
Hold on.
No state, governmental agency, or charitable organization is named in the will as a devisee. After the date of the will, there were no children born to or adopted by the decedent, and no marriage of the decedent was dissolved after the date the will was made. His will named Francis A. Perino to serve as independent executor, to act independently and without bond. And to the best of my knowledge, she is qualified and not disqualified to serve in that capacity. Your Honor, this is a non-taxable estate. We would request that appraisers be waived.
Well done. And everybody admits will of probate and authorized letters. Thank you, counsel.
Thank you, Your Honor. Have a great day.
You too.
Thank you.
Cause number 2, State of Heidi Ramler Felice.
Good morning, Judge.
Good morning. How are you?
Good.
You may proceed.
All right, Brandon Benoit here on behalf of the applicant. Heidi Ramler Felice passed away on December 18th, 2025 in Harris County, Texas. At the time of her death, she had a fixed place of residence and domicile in Wallaceville, Chambers County, Texas. She died leaving a will that was dated March 8th, 2002, which has been filed with the court. That will has not been revoked. She had no children born to or adopted by her after the execution of that will. That will names no governmental agency, state agency, or charitable organization as a devisee. The will named her husband, James Felice, to serve as independent executor. James Wallace Felice, excuse me. He predeceased Heidi back in July of 2025. The will then names Tiffany Michelle Felice Christensen and Jacqueline Christine Felice Chisholm to serve as co-independent executors. Ms. Chisholm has signed a declination to serve, and Tiffany is not disqualified and is qualified to serve as independent executor. This is a non-taxable estate. We'd ask that the will be admitted to probate, and that Ms. Christensen be appointed to serve without bond, and that appraisers be waived.
Well done. Thank you, counsel.
Thanks, Judge.
Have a good day, Brad. All right, cause number 3, the State of Rebecca S. Klaus. That's yours also?
Yes, sir.
And you may proceed.
I'm here on behalf of the applicant in this matter. Rebecca S. Kloss passed away December 13th, 2025 in Harris County, Texas. At the time of her death, she had a fixed place of residence and domicile in Baytown, Chambers County, Texas. She died leaving a will dated June 19th of 2019, which has been filed with the court. To the best of my knowledge, that will has not been revoked. That will does not name any governmental agency, state agency, or charitable organization as devizee. She had no children born to or adopted by her after the execution of that will. That will names Daryl H. Klaus to serve as independent executor of the will, but Mr. Klaus passed away on August 10th, 2022. The will then names Wesley Tyson Klaus to serve. Mr. Klaus is not disqualified and is qualified to serve. This is a non-taxable estate, and we'd ask that the will be admitted to probate, that Mr. Klaus be appointed independent executor to serve without bond, and that appraisers be waived.
Go now. Sir.
Thank you, Judge. Have a good day.
Okay. All right, call number 5, the state of Carroll Henry Harmon Jr.
Good morning, Your Honor.
Good morning, Ms. Clark. You may proceed.
And my client is here. He's identified as Ricky, and he needs to be sworn in as well once he.
He's, oh, I see Ricky.
Ricky.
Will you turn your camera on, Ricky? And unmute yourself.
There we go.
There he is. All right, raise your right hand, please.
Okay.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
Yes, I do.
Thank
You
you.
put your hand down, you may proceed, Counsel.
Thank you, Your Honor. Mr. Harmon, will you please state your full name for the record?
Carroll Henry Harmon III.
And goes without saying probably, but what was your relationship to Carroll Henry Harmon Jr.?
That was my father.
Thank you. And did your father pass away on January 28th, 2025 in Harris County at the age of 95?
Yes, ma'am.
And so it is correct that 4 years have not passed since the date of his death, right?
Right.
And did your father have a fixed place of residence in Chambers County when he passed away?
Yes, ma'am.
And is the document, I know you have a copy of it, and I'm looking at a copy as well, is the document dated September 18th, 2007? Mr. Harmon's, your father's validly executed will?
Yes, ma'am, it is.
And Your Honor, I request that you take judicial notice that the original copy of the will is on file with the clerk.
Right. Yes, ma'am.
Yes, ma'am, I have an original copy.
Thank you, Your Honor. And Mr. Harmon, this is not the original will that your father signed, is that correct?
That is correct.
And did you conduct a diligent search for the original will?
Yes, ma'am.
And what do you believe happened to that original?
He had a lot of paperwork and stuff at a location in Hancomer in a trailer. And when Harvey came through, everything was flooded. So I have no original records, only a copy that I got from the lawyers.
Okay, thank you, sir. And so this copy of the will is being offered for probate, and because the original has been lost, you are complying with Texas law and the rules of this court to notify your father's lawful heirs and the beneficiaries under the will that a copy is being offered for probate. Is that right?
Yes, ma'am, that's correct.
And is it true that everybody who's listed in the application, the heirs and the beneficiaries or devisees under the will consent to your filing a copy of this will and will sign waivers agreeing to this?
Yes, ma'am. I don't think I have any trouble with that.
Okay, thank you. And do you, back to the will, do you recognize your father's signature on that will that you have a copy of?
I'm sure I did. Let me get a copy. Yes.
Okay, thank you. And to the best of your knowledge, was this will ever revoked?
No.
And is it correct that no children were born to or adopted by your father after the date of the will?
That is correct.
And is it also correct that your father's marriage to your mother, Margaret Ann Pugh Harmon, ended at her death on May 8th, 2010, and that no other marriage was dissolved after the date of the will?
That is correct.
Is it correct that the will does not name the state of Texas, a charitable organization, or any governmental agency of the state of Texas as a devizee or beneficiary of the will?
That's correct.
Is it your testimony that there is a necessity for an administration of this estate because you need to pay, there are debts to pay, but also to transfer title to the estate assets?
Yes,
And is it true that you're named as independent executor to serve without bond in this will?
yes, ma'am.
However, is it true that you decided to proceed with a dependent administration due to debts of the decedent, your father?
Yes,
And is it true that you're not disqualified, but you're qualified by law from accepting letters of administration with will annexed?
yes, correct.
Okay. Now, Your Honor, I'm going to ask some questions about the nature of the estate. Mr. Harmon, is it true that the only assets of your father's estate are, number one, the homestead located at 606 Stowell in Anahuac, Chambers County, Texas, 77514, with the current appraised value according to the Chambers County Appraisal District of $106,670. That's
Yes,
one.
correct. Yes,
And 3 landlocked parcels that totaling 3.412 acres that are located in Chambers County, with the Chambers County Appraisal District appraised value of $20,400.
yes, ma'am.
And number 3, there's $84.96 in a Stellar Bank checking account,
That's correct.
and a claim of approximately, I think it was $385, which is the total of 2 refund checks from Discover Card,
Yes,
and then a claim of $117, which is a refund from Exxon that related to medical payments.
yes, ma'am, that's correct.
Okay, and that comprises the entire estate, correct?
Yes, ma'am.
Okay. However, is it your testimony that the market value, the fair market value of the real property is lower than the appraisal district's appraised value?
I think it probably will be because of the condition of the home.
Okay, because of the condition of the home. What would you estimate, what would you estimate the fair market value of the homestead would be?
I've had it appraised anywhere from 70 to 100,000.
Okay, and that was
Okay.
not an official appraisal, a
No.
certified appraiser, but a broker's opinion of value, is that right?
Right, that's correct.
Okay. And then with regard to those 3 tracts, is it correct that they're completely landlocked with no road access or even an easement?
That is correct.
And did your father sell another tract several years ago, which was on a road, but similar, other than that, for $2,000?
Yes, ma'am.
Is it also correct that your father tried to sell these 3 tracts before he passed away?
That is correct.
And what was the result of that attempt?
Nobody was interested in landlocked land.
Yeah, with no easement and no road, correct?
Right.
Okay. Thank you. So in summary, is it correct that the total value of the estate using the Chambers County Appraisal District appraised values is $127,656.96, but with a fair market value estimated as low as $76,586.96?
I haven't added it up. That sounds real close. Yes, ma'am.
Okay, thank you. And that the value of the estate without the homestead is at the top about $20,000, almost $21,000, and maybe as low as $6,500, based on the marketability of the property.
Yes, that's correct.
So, and there's cash of the $586.96.
Yes,
Okay. And then just to date, you've paid property taxes and insurance out of your pocket. Is that correct on all the real property?
yes, ma'am.
Okay. And you have paid approximately, I know, did you pay about $1,500 this year for property taxes out of your own pocket?
I think it's around 800 or so, something.
Oh, okay. Maybe
Just for property tax.
that would be 2 years, maybe?
No, this was the last taxes with the 800 and something. The
Okay.
prior years, I didn't see any paperwork or anything on that. I have to go and dig all that up.
Okay,
For
but you
prior years.
paid out of your pocket in the past as well, not just
Yes,
this year?
yes,
Okay, thank you. And you've got other out-of-pocket expenses such as funeral expenses and a headstone, is that correct?
that's correct, yes.
Okay, all right. Your Honor, we would like to ask that you admit the copy of the will of Carol Henry Harmon Jr. to probate and to name Carol Henry Harmon III as dependent administrator with will and next, to serve with the minimum bond necessary based on the estate, in order that appraisers be waived.
All right, so how much was in the bank account?
$84.96.
And was there anything else that's liquid asset?
There are just a couple of checks that are refunds payable to the estate, and so the total is $586.96.
All right, so I'm going to approve the order admitting copy of the will of probate and a $600 bond.
Thank you, Your Honor. Would that be a cash bond in this instance?
It can be, Christie, either way is fine, isn't it? Yes.
Okay. Okay, thank you, Your Honor.
All right, thank you. You have a good day.
You too. Thank you, Mr. Harmon.
Thank you,
Take care.
thank you.
All right,
Bye.
cause number 7, interest of Madison Cheyenne Pretty Talgie.
Dalgy.
Talgie.
Yes,
All right. And you're here on that.
yes, sir.
And this is a transfer of guardianship from Galveston County, is that correct?
Yes, sir.
Okay. So are you going to testify, ma'am?
Yes.
Go ahead, you may proceed.
I got custody over after my mom passed. We're just trying to get everything transferred over. I am still her legal guardian. I put all the paperwork to Galveston. I'm not sure they transferred it over. They did? Okay.
They did. I'm
So
looking at it.
yes, sir.
All right, so, and has anything changed as far as her finances?
No, sir.
I see the Galveston County Court set the bond at $100.
And it did not transfer over, so.
I see that.
Sorry, I've been trying to get a hold of Debbie and she hasn't responded.
All right, so I'm gonna accept the transfer. Set the bond at $100, and if they transfer it, that will cover it.
Okay.
All right. Good luck, ma'am.
Thank you.
You're welcome. Take care. All right, cause number 7. Oh, that was okay. Cause number 86 in the matter of Tyler Ogden.
Yes, Your Honor. I have Mr. Ogden, I believe, on the screen. He's I think in the hospital with his wife.
Okay.
I see that he's muted.
Yeah, can you unmute yourself, Mr. Ogden?
I think I'm unmuted now, right?
You are. We can hear you. You may
Okay.
proceed, Counselor. Ms. Lane, you may proceed.
Mr. Ogden, could you state your full name for the court, please?
Joseph Piner Ogden III.
And Mr. Ogden, you are the appointed guardian of Tyler Ogden, Tyler Russell Ogden, is that right?
Correct. Yes, ma'am.
And we've been before the judge on several occasions on especially the sale of these lots. Now, you presented an application to the court not last year on the order of sale of the first Bragg Road in Hardin County. Is that right?
Yes, ma'am.
And we sold that property through, I think, Stewart Title in
Yes,
Hardin
ma'am.
County. We have the second Bragg Road, similar dimensions, just a tad off that we have before the court today. Is that right?
Yes, ma'am.
Now, in the last sale, the court granted you past due guardianship. You'd been on there like 10 years, never reimbursed yourself, and the court granted you a past due value from the sale of that property.
Yes,
Is
ma'am.
that correct? And
Yes,
you
ma'am.
have established through a pooled trust from the Ark of Texas through JP Morgan, also on behalf of Tyler Ogden. Is that right?
Yes, ma'am.
And he's still very happy. I know the staff from being with you a while at the Jubilee home in Beaumont, Texas.
Yes, ma'am.
And he's continued to be placed there. One of the purposes of the sales of these two lots is they're non-productive, they're land, and you've been paying the taxes.
Yes, ma'am.
So now we have a buyer, and Your Honor, I have the application for sale, but on the heels of this, I'm preparing to give the court this. It's a report of sale that actually has the title commitment, the unimproved property contract that was sold for basically the same price as the other one. I think this one's 45,000. The other one was 45,000. It's a different buyer, and a third party addendum financing for 40,500 of it. The buyer has put an earnest money of 500 and 4,500 down. So there is funds here for the to be placed for the guardianship to go towards it, but also as a safety net. And that Mr. Ogden, are you asking for $200 for the future? We've paid up for the past. We dropped our amount from what it was because now it's mainly monitor of 200 a month, no more than 2,400 a year for you to look after Tyler through Jubilee and his ARC investments. Is that
Yes, ma'am.
correct?
Yes.
Now, in the ARC, he does have a considerable amount of money pooled with other young adults like him. Is that correct?
Yes, ma'am.
So there's some of this funds, are we expecting to keep that in a separate fund? Or are we going to place that partial or all or partial into the ARC?
We're going to place it partial in the ARC once I get the Jubilees asked me to do a funeral plan for him. So I'm going to use the funds to pay for that, and then the balance will go to the ARC.
Okay.
I know
Okay.
that's new. I was just asked about that actually
Another,
yesterday.
that opens another question. I know he was adopted and his parents are buried. Is he going to
Mhm.
be buried near his parents?
There's a plot right next to Bruce and Rita. Yes, ma'am.
And will that money include a tombstone?
Yes, ma'am.
Okay. All right. I
Yeah,
didn't
but
remember that fact.
I
you know how
know,
much
no, this
this,
is new. Go ahead,
do you have a
Judge.
price for that?
No, sir. I just
Okay.
found out about it yesterday. I've got to go. I'm going back to the funeral home that had the plan for Rita and Bruce. I can't remember their name. It's there in Winnie.
Broussard.
Oh, Broussard. Yes, sir.
Okay.
And uh, I'll work out the plan, similar plan to what Bruce and Rita had there with them, but I
Right.
don't have a price yet. Once I get down there and meet with them, I got to get my wife out of the hospital so I can. But as soon as I
Well,
get
good
that
luck with
done,
it.
yeah.
All right, Counselor.
So I see what you're doing, Mr. Ogden. I know that, no offense, but you're a little bit older than Tyler, and you may not be around, and you're
Yeah,
it.
that's
So
basically what Jubilee said. Yeah.
yeah, so you're it. So I see your point. I'm sure the court does too. We want to make sure those arrangements are taken care of as well when you're
Yes,
gone.
sir. Mm-hmm.
Um, so basically, Your Honor, I'm going to send you all the documents today on the title commitment, the description of the property, the unimproved contract, the amount of 45 is what the court approved on the other, and the third party addendum that shows the financing that has been approved, and a disclosure statement on the property. And ask that the court, I know Stuart Title has been calling me consistently about today, so I want to make sure I do it timely, that we don't lose the buyer. So I was going to file the report once you sign the order, Lord, sorry, Judge, so that I've been praying a lot. So anyway, so that I can close for my client on February the 12th.
Okay, and then you'll have an accounting of where the money's going.
Yes,
Yes,
sir.
Mr. Ogden's good. So you hear that, Mr. Ogden? I want you to
Yeah.
get us a copy of, you know how they give you the little form of
Yeah.
the cost
Yeah,
and
all the detail in the booklet and
all
everything
the
comes with that
details. You
copy.
might want to consider Tombstone, because if you don't, okay, and the value of that, and then we know that the court, I need direction from the court, Judge. Do you want it to be an option where he could hold back on two every month, and if he chooses and he doesn't use it that month, he could apply it for the next no more than 2,400 a year? Is that reasonable to you, Judge?
I think it would be
Um,
2,400 a year is not too much to handle.
Yes, and I
Okay.
will say, I'm not just bragging because he's listening, but I've talked with Jubilee since we've had this case. It's 3 or 4 years. He is consistently being cared for. They do have community where they drive him places, and he has his cell phone and his little iPad. So he's getting older, but they love him. They know him, and they know Mr. Ogden, and they've got a really good routine for a good life, considering his disability.
Yes, ma'am. All right, I'm gonna approve the application for the order to sell a second Bragg Road real property.
All right. Well, thank you, Judge, and I will
Thank
be
you.
getting this
Thank
report
you.
for you too.
All right, good luck, sir, with
Uh,
your
Thank you,
and
sir.
hello, Miss Christie.
Hi, how are you doing?
Pretty good. So, all righty. Well, thank you.
I don't see oh, that's just the application. You're sending over the order.
Uh, No, you're on. We e-filed one order was missing, and that's the other case. No, I have the
I
order
found
that
it.
it was
Never mind, it was
e-filed.
right on top.
It's there. It may not have made it to you, but it's there.
I got it. All right,
And
it's done.
Judge,
Yes,
may
ma'am.
I ask one thing? Mr.
Sure.
Ogden, while I have you on screen where you can hear me, I
Mm-hmm.
need you to review this report and sign it, and we'll notarize it for you for the court, okay?
Okay.
We need you to get this back to us,
Yes,
okay?
ma'am.
All
All
right.
right, take care. Everyone have a good day.